Pues muy buenos días, bienvenidas, bienvenidos. Good morning, welcome, Professor.
Thank you.
It's an honor for us to have here Professor Martin Borowski, a distinguished professor at Heidelberg. Yeah. And he's going to be with us the next week, and today it's time to introduce his distinguished career. Voy a leer simplemente un breve resumen curricular para presentar al profesor Borowski. Él es profesor titular y director del Instituto de Derecho Constitucional, Teoría Constitucional y Filosofía del Derecho de la Facultad de Derecho de la Universidad de Heidelberg y doctor en Derecho de la Universidad de Kiel, Alemania, título otorgado con honores de summa cum laude, y que él recibió el premio además de la Facultad de Derecho de la Universidad de Kiel del año 1997, así como el premio de la Asociación de Birmingham, de Kiel de Doctores Juris del año 1998. Ha sido profesor de la Universidad de Birmingham en Reino Unido, y de la Universidad de Westminster también en Reino Unido. Becario del Instituto Whitney R. Harris de Estudios Legales Globales en la Universidad de Washington en San Luis, y obtuvo su nombramiento como private docent en el año 2004 por el Senado de la Universidad de Kiel en Alemania. Es además miembro de distintos comités editoriales y bueno, nos da muchísimo gusto tenerlo aquí. It's very, we are very happy to have you here, profesor, y porque precisamente la intención de este tipo de actividades es escuchar al profesor Borowski, pues creo que le dejaría usar la voz. Profesor, we are here to hear you, so the floor is yours.
Thank you very much for the very, very kind words of introduction. I have to apologize for not speaking Spanish. I can't. And my attempt to do so would leave you probably in a very funny mood. The topic is Radbruch's formula and constitutional review. I will say something on that in a second. But to begin with, I shall thank Professor Ina Flores, Professor Rodrigo Brito, and Professor Sonia Venegas for their kind and generous invitation to UNAM for this presentation here today on legal philosophy and constitutional review, and a series of presentations on legal argumentation next week. So there will be some Flores, classes, Professor Rodrigo Brito, and Professor Sonia Venegas for their kind and generous invitation to
my presentation
today for this presentation here today on legal philosophy and constitutional review,
separately.
And
this is
a series of presentations on legal argumentation
about the things you think you know.
So there will be Suna Flores, classes, Professor Rodrigo Brito, and Professor Sonia Venegas for their kind and generous invitation to my presentation today for this presentation here today on legal philosophy and constitutional review, and this is a series of presentations on legal argumentation. So there will be Suna Flores, classes, Professor Rodrigo Brito, and Professor Sonia Venegas for their kind and generous invitation to my presentation today for this presentation here today on legal philosophy and constitutional review, and this is a series of presentations on legal argumentation theory. So there will be Suna Flores, classes, Professor Rodrigo Brito, and Professor Sonia Venegas for their kind and generous invitation to my presentation today on this presentation here today on legal philosophy and constitutional review, and this is a series of presentations on legal argumentation theory. So there will be Suna Flores, classes, Professor Rodrigo Brito, and Professor Sonia Venegas for their kind and generous invitation to my presentation today on this presentation here today on legal philosophy and constitutional review, and series of presentations on legal argumentation
merely a relative necessity, inclusive positivism,
or is an absolute impossibility, exclusive positivism. I'm saying that because I know that north of your border, the people in the United States are very excited about this positivistic distinction. I don't think it's that important, to be honest. The traditional main argument on behalf of legal positivism in the German debate, the argument from relativism, counts against both inclusive positivism and non-positivism at the level of criteria for the identification of valid law. So that, continuing my criticism, so to speak, so that the idea of inclusive positivism strikes me, which people call a middle ground, as something half-hearted. Compromise, middle ground, may sound appealing from a pragmatic point of view. In academic debates, such solutions all too often turn out to be rotten compromises. Fauler Kompromiss, we say in German. If there can be cognition of morality with sufficient certainty, the main argument of exclusive legal positivists is rebutted. Human rights as moral rights with certain, even if modest, universal and eternal content are very plausible candidates for the minimum content of natural law. To borrow a phrase from H.L.A. Hart, Hart would not be happy with my use here, I'm aware of this. It is not without reason that both Gustav Radbruch and Robert Alexy mention the core of human rights for determining the minimum content of natural law. Why should it then be a merely contingent issue whether the validity of law is dependent on a minimum content of natural law? So if you agree to that, then go to non-positivism. Considering the law's inherent claim to correctness, genocide or atrocious ethnic cleansing at an industrial scale, such as the Holocaust in Germany, middle of the 20th century, cannot be regarded as expressions of valid law. To be sure, it is unclear, uncontested, where the precise dividing line between legal positivism and legal non-positivism lies, but I will not go into this here in greater detail. Let us focus on clear cases of non-positivism, and first and foremost here, Radbruch's formula. I think many of you have already heard about Radbruch's formula. Many of you may not have heard that it has two parts, because this is often neglected in the debate. The Radbruch formula is such a clear case of non-positivism, and the two parts deserve attention. The first part is the intolerability formula, Unerträglichkeitsformel in German. The second part is the disavowal formula, or betrayal formula, sometimes also called Verleugnungsformel. The intolerability formula runs as follows. Now comes the famous quotation by Gustav Radbruch. The conflict between justice and legal certainty plays a big role in what's coming, may well be resolved in this way. The positive law secured by legislation and power takes precedence even when its content is unjust and fails to benefit the people, unless the conflict between statute and justice reaches such an intolerable degree, intolerable is here the phrase, intolerable degree that the statute as flawed law must yield to justice. It is impossible to draw a sharper line between cases of statutory lawlessness, intolerable tension, and statutes that are valid despite their flaws. No intolerable injustice. And after this passage, the characterization of the disavowal formula immediately follows. One line of distinction, however, can be drawn with utmost clarity, where there is not even an attempt at justice, where equality, the core of justice, is deliberately betrayed in the issuance of positive law, then the statute is not merely flawed law, it lacks completely the very nature of law. Just briefly, the two parts of Radbruch's formula have roots in different parts of his legal philosophy. The intolerability formula has its foundation in Radbruch's theory of legal validity, the disavowal formula in Radbruch's concept of law, two separate parts of his theory. The conditioning criteria are different. The conflict between statute and justice reaches such an intolerable degree versus justice is deliberately betrayed in the issuance of positive law. The conditioned consequence is different. Flawed law must yield to justice versus the statute is not merely flawed law. It lacks completely the very nature of law. Different. What is more, the certainty vis-à-vis their respective applications is different. Intolerability, impossible to draw a sharper line, difficult. Versus disavowal, line can be drawn with utmost clarity, easy to establish. Most commentators focus completely on the intolerability formula and ignored the disavowal formula. One prominent example is actually Robert Alexei in his defense of the Radbruch formula. To be blunt, Alexei actually defends only the intolerability formula, the first part, not both parts of the greater formula. And this is based on an often repeated but nevertheless misguided subjective reading of the disavowal formula, which in my view needs to be understood as objectively referring to extreme discriminations. This is key for Radbruch. Equality, extreme discriminations, outrageous violations of equality. Radbruch actually employed the disavowal formula. Not many people have seen this, I think. Radbruch employed the disavowal formula, pointing at the outrageous and extreme discrimination of fellow human beings to overcome the iniquitous statutes and iniquitous legal practice of the Nazi regime. By contrast, he did not employ the intolerability formula. In Alexei's more simplified approach, these two parts of the Radbruch formula collapse onto the phrase extreme injustice is no law, his argument from injustice. Even though this cannot count as a proper explanation of Radbruch's formula with its two parts, from a systematic point of view, granted, Alexei's version may be more easy to justify. Intolerable injustice and disavowal of justice, if properly understood, may count as two instances of extreme injustice, and both lack of legal validity, intolerability, and lack of legal character, disavowal, may count as two instances of no law, in some sense. This is an interesting debate. It goes, however, beyond the thrust of my argument today. Alexei defends his non-positivistic approach by advancing three main arguments: the argument from correctness, the argument from injustice, and the argument from principles. The important argument from injustice has 8 aspects: language, clarity, effectiveness, legal certainty, relativism, democracy, dispensability, and candor. It would be tempting, I will not, it would be tempting to explain and continue the debate on behalf or against Alexei's non-positivism. But my focus today is again elsewhere. For the sake of my further inquiry, we shall simply assume, just gift me that for the time being, we shall simply assume that something akin to Alexei's argument from injustice, extreme injustice is no law, holds true. If you disagree, we have a discussion, feel free to ask questions, that's fine. But it just, so to speak, for the sake of the argument. Good. Now, this is basically an introduction into the main strands of the Radbruch formula. Now I'm coming to my argument. The Radbruch formula and Alexei's extreme injustice is no law. These phrases do not apply themselves to cases. It is persons or organs of state who apply such standards in a system of distributed legal powers, but which persons or organs are empowered to do so. And here we have, from the middle of the 20th century, one attempt. This is the attempt by H.L.A. Hart at characterizing Radbruch's theory in his famous article, Positivism and the Separation of Law and Morals, in Harvard Law Review 1958. And here we read, I now quote H.L.A. Hart, quote, "It is clear that Radbruch's doctrine meant that every lawyer and judge, this is important, every lawyer and judge should denounce statutes that transgress the fundamental principles not as merely immoral or wrong, but as having no legal character. And enactments on which this ground lack the quality of law should not be taken into account in working out the legal position of any given individual in particular circumstances. Now, interestingly, this is clearly and demonstrably false. It's simply wrong. Radbruch explicitly says something different in an important respect. Now to quote Radbruch, shorter. Not every judge acting on his own initiative should be allowed to invalidate statutes. Rather, this task should be reserved to a higher court or to legislation. Now the question is, how could it come to such a, what I would call, blatant misinterpretation by H.L.A. Hart? In footnote 42 on page 617 of his essay, Hart explains that he had used, quote, used the translation of part of this essay and another source, which is not relevant here, prepared by Lon Fuller of the Harvard Law School as a mimeographed supplement to the readings in jurisprudence used in his course at Harvard. We know that Lon Fuller was strongly influenced by Gustav Radbruch, but digested this into a completely different view. This is known. Now, we do not know which parts of Radbruch's article were missing in Fuller's partial translation. Maybe he missed the statement of Radbruch I just mentioned. But even so, the question remains why Hart felt empowered to make a firm statement with the prelude, "It is clear that." Now, having spent 6 years in the United Kingdom, if a British person says to me, "It is clear that," I always kind of go on the backs, so to speak. It is clear. No, not at all. Without knowing Radbruch's text completely, and without understanding Radbruch's theory, frankly, properly. I might mention that Hart's exposition of Radbruch's theory has other problems. Okay, I will not go into this here and save some time. So this is, I think this is a big misunderstanding and mischaracterization by Hart. Now, why is this important? This is important because there's a huge difference in terms of legal certainty. In the European debate, legal certainty counts as the most powerful argument against moral criteria for the identification of valid law. To the extent that the cognition of morality is difficult and questionable from an intersubjective point of view, it proves problematic to include it by means of non-positivism or inclusive positivism into the criteria for the identification of valid law. A case that Hans Kelsen made powerfully throughout all the time. It's irrational, we can't include it. Hart's phrase, every lawyer and judge, does not mean only every judge. Then lawyer and would be completely superfluous. This phrase means every lawyer and every judge. In essence, everyone who is concerned with the interpretation of the law. The task of the interpretation of the law does not only extend to interpret the content of the phenomena, which are unquestionably law, but also to the question whether a phenomenon actually counts as valid law, the identification question and the content question. If the competence to declare parliamentary statutes null and void is centralized in and monopolized at a single high court, be it a distinct constitutional court or a Supreme Court, there is more legal certainty compared to a situation in which every court is empowered to make such declaration, let alone compared to a situation in which every practicing lawyer may advise a client that this or that parliamentary statute is supposedly null and void and needs not to be followed. This is anarchy, actually, at the end, the anarchy argument. This is to say that legal certainty is not only crucial for the justification and interpretation of the Radbruch formula as a substantive standard for identifying valid law. The argument from legal certainty is also key for the institutionalization of the Radbruch formula in any given legal system. Legal certainty demands the centralization of the power to declare abstract legal norms null and void. And this undergirds Radbruch's demand of centralization in his famous article from 1946. And this refers to one of the key distinctions, now moving to constitutional review, to the key distinctions in the reconstruction of constitutional review, the distinction between centralized and decentralized constitutional review. In every liberal democracy with a constitution and parliamentary legislation, there can be a conflict between the constitution and parliamentary statutes. Here courts are in a predicament because they are committed both to uphold the constitution and to uphold parliamentary statutes. The constitution represents higher law, but the legislator objectively claims, with this act of enacting the statute, objectively claims that his statute is in conformity with the constitution. So what to do? The US Supreme Court answered this question in 1803 famously in favor of upholding the constitution and bestowed this legal power on every federal court in the US. This is decentralized constitutional review. Decentralization or centralization is, however, I would say, a matter of degree. The US-American solution is centralized insofar as only federal courts and not state courts or even federal agencies, the administrative, are empowered to declare acts of Congress null and void. And it is decentralized insofar as all federal courts are empowered to do so within the jurisdiction and with effect inter partes. By contrast, the main thrust of the development in Europe was different. The same problem was solved differently by Hans Kelsen in his capacity as a scholar in constitutional theory and constitutional law. He was a multi-talent, as we know, in drafting the Austrian Federal Constitution of 1920. He developed centralized constitutional review. Here, only a single high court, typically an institutionally distinct constitutional court or a Supreme Court with the constitutional function, is empowered to declare statutes null and void. Such decisions typically are binding erga omnes in the legal system. The Austrian model was adopted by the German Basic Law in 1949, actually 3 years after Radbruch's famous article with his formula. So Radbruch was early as a criminal lawyer with this idea, interesting parallel, and became, following the influence of German legal thinking, a model for many constitutional systems in Europe and beyond. Many people actually think centralized constitutional review is a German invention. It is Austrian, and Austria is not part of Germany. It's part of the German culture to a certain extent, but I will not actually antagonize my Austrian colleagues by kindly embracing them as German. They don't like that. Okay, so I should, and in fairness, it's an Austrian development. It's worth mentioning that often, at least in the English-speaking world, centralized constitutional review is equated with abstract review. This is, strictly speaking, mistaken. The German constitution knows, apart from the constitutional complaint, completely different thing, both abstract and concrete review. And both are forms of centralized review. There is abstract centralized review without any historic model before that. Here, the federal government can challenge the constitutionality of state statutes or regulations. State governments can challenge the constitutionality of federal statutes or statutes of other states, not their own states, but other states. And third possibility, 1/4 of the members of the federal parliament, basically the opposition in the federal parliament, can challenge the constitutionality of federal statutes or state statutes. Completely abstract, no legal case. There's no underlying legal case, and only the decision is taken there. It's completely new, 1949. The classic form, which is the counterpart of Marbury in medicine, is concrete centralized review. And here there is a legal case before an ordinary court. If the question of the constitutionality of a parliamentary statute arises before an ordinary court, they have to apply it, but is it constitutional? If it's not constitutional, how can they apply it? The Marbury medicine question. The court is obligated and empowered to form an opinion on the constitutional issue. This is the first step. They have to form an opinion. If the court comes to the conclusion that the statute is constitutional, positive answer, then the ordinary court proceeds to decide the underlying legal case based on the statute considered constitutional. If the ordinary court comes, however, to the conclusion that the parliamentary statute is unconstitutional from their point of view, then the ordinary court is neither empowered to quash it with effect erga omnes, nor even only disregard it with effect inter partes. Instead, the ordinary court must formally halt its proceedings and refer the constitutional question to the Constitutional Court. The Constitutional Court decides the constitutional question with effect erga omnes. Based on this decision, the ordinary court resumes its proceedings and decides the case at hand based on the decision on the constitutionality of the statute by the Constitutional Court. The parties of the underlying legal case before the ordinary courts have no claim right that such reference is made by the ordinary court. They can't require the court to do so. Whether or not a reference is made depends solely on the assessment of the constitutionality by the ordinary court. At the end of the day, any party can file a constitutional complaint, this comes into play here, against the final decision of the ordinary courts based on the alleged unconstitutionality of the statute that undergirds the final decision of the ordinary court. So they can appeal against the final decision, which is, strictly speaking, not final then, because the legal base applied was unconstitutional. So this remains possible. And of course, the Constitutional Court cannot undertake concrete review without a reference made by the ordinary court. They can only react to references of ordinary courts. And the Constitutional Court always wants to see the whole file of the underlying legal case. Even if the decision is formally only on the abstract question of the constitutionality of the statute, it is always taken in the context of the concrete case. They want to see how this plays out in practice, and typically also whether interpretation in conformity with the Constitution is possible. If not, it's unconstitutional. If yes, it remains in that interpretation valid law. Okay. To be precise, now you learn a lot about the German court system today. To be precise, the centralized concrete review in the German legal system applies only to parliamentary statutes, to federal statutes or state statutes. For regulations, both federal regulations and state regulations in Germany, there is decentralized constitutional review. The ordinary courts can disregard regulations considered unconstitutional with effect inter partes. As already mentioned, centralization is a matter of degree, so we actually have a mixed system. But for the important parliamentary statutes, it is centralized. The legal system of the European Union, no, I will not say much on that, follows the idea of concrete review with the Article 267 preliminary reference procedure, a treaty on the European Union. So they basically follow the German model, which is Austrian. Good. To conclude the issue of centralized review, Radbruch's idea in 1946 that only a single court should be empowered to undertake what I would call natural law review, Radbruch formula, in a legal system is perfectly compatible with the Austrian-German tradition of centralized constitutional review. And this enhances legal certainty, a moral and legal value that Radbruch rightly cared much about. Good. Now you learn from the quotation that Radbruch does not only mention a centralized court, he also mentions the legislator. Would it not be a better idea to leave the issue of overcoming iniquitous statutes of rogue regimes completely to the democratically elected legislator and leave the courts out of the play completely? Okay, let's look at experience in the past. For example, after the military defeat of Germany in May 1945 and before Germany's state structures were rebuilt, leading to liberal democracy we have now, the Allied Control Council, the four powers that won the Second World War, the Allied Control Council assumed the exercise of public authority in Germany and on behalf of the German people. Immediately after assuming authority, the Allied Control Council issued Control Council Law Number 1 of 20 September 1945, repealing the most egregious Nazi statutes and regulations, the signature, racial, statutes and regulations of the Nazi regime. These statutes then could no longer be applied, which solved the problem at that point in time for the future. Statutes are gone, no problem. Repealing a statute or regulation does not, however, change the legal situation in the past. Any amendment or repeal of an abstract and general legal norm has effect ex nunc, an effect from the moment of amendment or repeal on. This can be different if there is explicit retroactive effect, which then poses problems with an eye to the rule of law, most importantly in criminal law. The Control Council law of 20 September 1945 did not, however, have any retroactive effect, and the same applied to the German constitutional provisions dealing with the problem. Summing this aspect up, the problem is that the legislator may, for whatever political reason, fail to repeal inequity statutes of former rogue regimes. And even if such repeal happens, this has no retroactive effect. To solve the problem, thank you, comprehensively and with certainty, courts, or preferably a single centralized court, as just explained, must be empowered to take action. And there is actually another fundamental distinction in constitutional review, the distinction between the constitutive decision of invalidating an unconstitutional statute with effect ex nunc, from now on, and other possibility, the mere declaration that an unconstitutional statute was null and void ex tunc, from the beginning on. And here, Austria and Germany differ fundamentally. While the Austrians, following Hans Kelsen's writings, assume the idea of invalidating unconstitutional statutes ex nunc, in German Vernichtbarkeitslehre. The Germans traditionally prefer the idea of merely declaring null and void, that what was just that from the outside, null and void. Lehre der Nichtigkeit ipso jure. Even if everyone around, officials and citizens, treated these statutes as valid law for the time being. It is obvious that the German approach of merely declaring extremely unjust statutes from null and void ex tunc is more helpful in overcoming inequity statutes of rogue regimes. There is no questionable retroactive effect necessary, since the statutes never became valid law. And this is particularly important in criminal law and plays a role in the debate. Radbruch and Alexei both implicitly, they don't say this explicitly, I would say, they implicitly assume this German approach. For Radbruch, both parts of his formula, and Alexei, with his argument from injustice, extreme injustice in the law, he does the same. And finally, I'm coming slowly to the end, finally there's another problem in natural law review that is known from constitutional review, and this is now a bit more public law. What happens to individual acts whose legal base is declared unconstitutional owing to being extremely unjust? For the Austrian approach, this is rather simple. For the legal base was valid at the time the individual act was issued. This means that the individual act was lawful from the outset. This does not change if later the legal base of the individual act is invalidated with effect ex nunc by a constitutional court, because it has no retroactive effect. Any attempt to change the validity of the individual act must explicitly have retroactive effect. And the Austrians have to do something in their reconstruction of constitutional review along these lines. Now on, and here comes a twist in the German doctrine of public law, because while unconstitutional or unlawful general norms in the German view are regarded as ipso jure null and void from the beginning, this does not apply to individual acts such as judgments or administrative acts. So when it comes to individual legal acts, the Germans turn into some kind of Austrians. We mix that again. If they are merely unlawful, judgments or administrative acts, they continue to be valid. They can be invalidated by means of appeal in the normal canals of appeal, but there's typically a deadline for this. When the deadline has passed, nothing can be done. And this is to say that with an eye to individual acts, Germany follows basically the Austrian tradition of invalidatability. I invented this, no, it was Stanley Paulson invented this English term that didn't exist before one thought about this problem. Rather than being considering the act being null and void ipso euro. And again, there are exceptions to that. In German public law, if the defectiveness of an administrative act is obvious, blatant, then they are actually automatically null and void. Then it goes back to this ipso euro ex tunc. Okay, this is the general backdrop. We have for constitutional review in the current German legal system a special provision on the effects of unconstitutional norms on individual acts based on an unconstitutional legal base. This is section 79 of the German Federal Constitutional Court Act. If an individual act has been issued, judgment, administrative act, and is still subject to appeal, it will be invalidated on appeal. Now we know that it had no legal base from the outset. This is normal, so to speak. But if it is not subject to appeal anymore because the deadline has passed, then the situation is, metaphorically speaking, frozen. The situation is frozen means individual acts remain valid. They do not lose their existence validity because of loss of legal base. They remain valid. If they have already been enforced, this is not unwinded. This is not undone. It stays as it is. Enforced, it stays that way. If the act remains valid but has not been enforced yet, enforcement action is forbidden. It's a kind of compromise. And if the act remains permanent halt of enforcement. And if the process of enforcement had begun but has not been finished, again, it has to be halted permanently. And this is a compromise between the lack of authoritative issuance, there was no legal base for the individual act, we now know, on one hand, and the fact that there was already clearly social validity. Everyone assumed that the relevant statute was valid law in the legal system before it finally turned out to be unconstitutional from the beginning on. Now, let me just say quickly, I doubt that this German compromise for unconstitutional norms just explained is appropriate for extremely unjust law. I will come back to this issue in 2 minutes. In the German debate on extremely unjust law, the focus was and is very much on general norms. In my view, it is actually decisive whether a human being is exposed to extremely unjust individual acts. In the individual act, or in Hans Kelsen's parlance, the individual norm, the demands of the legal system have been fully individualized and concretized, and there is the threat of immediate legal sanction, realizing the legal ought in fact in the real world. And this is what counts for the individual. Now, one might be tempted to say that there is no meaningful difference between extremely unjust statutes and extremely unjust acts, individual acts. No meaningful difference because extremely unjust general norms lead to extremely unjust individual acts. This might be true for typical cases of application, but I'm far from sure that this is the whole truth. I can imagine a general norm that is in and of itself not extremely unjust, but is applied in an extremely unjust fashion. And that was actually the typical strategy of German Nazi judges, the strategy to concretize general clauses, Generalklauseln, very open provisions, against the backdrop of National Socialist political ideology, so that concretization by courts was extremely unjust, rather than the general norm itself. And such cases are missed if one focuses exclusively on extremely unjust general norms. Something we learn also from constitutional review. One might also ask whether there can be atypical cases of application of extremely unjust general norms that result in individual acts that are not extremely unjust. It's a bit theoretical, but you know, working out the differences is, I think, helpful to ask these very pointed questions. Good. If the individual act is decisive, and if one can establish with sufficient certainty that this very individual act is extremely unjust, then the situation differs, I think, from the typical situation in constitutional review. The unconstitutionality of a general norm is often not obvious. Sometimes for experts it is, but politicians do not always listen to legal experts. While the extreme injustice of a general norm on individual acts is by design obvious. If it's not obvious, you do not have enough certainty to say that there is a case for the Radbruch formula. So it's by design. And this calls, in my view, for regarding extremely unjust individual acts as null and void ab initio ex loc, different to what we do in the Constitution. But let me conclude. Legal philosophy is supposed to have practical implications. It is not something detached from legal practice, floating in some sky above everything else. Moral limits of valid law, such as justified with Radbruch's formula or Lexis argument from injustice, need institutionalization in the legal system at hand. The German approach to the institutionalization of constitutional review provides outlines to the institutionalization of natural law review, although there may be certain limits to parallels between these two forms of review, as just explained with the individual acts. Of course, if you are an exclusive positivist, you disagree with the very idea of Radbruch's formula and Alexis' argument from injustice, so that there is nothing to be institutionalized. But if you are, you probably have stopped listening after 3 minutes, maybe. However, understanding how this very idea, non-positivism, might be institutionalized in a liberal democracy, and grasping that there are many parallels to constitutional review, this very idea might actually look a bit more convincing. Thank you for your kind attention.
Thank you very much, Professor Borowski. If someone has questions, comments.
And I'm also happy to answer questions on the Radbruch formula as such, because I was very brief on that. So,
okay.
Yeah, whatever you're interested in.
Yeah. If you can explain a little bit more about Radbruch formula, please.
According to Radbruch, there is a conflict always between legal certainty on one hand and the justice. And if a legislator enacts a statute that is unjust, we are in a difficult situation, because justice requires us to say, well, we cannot apply this law because it is unjust. But legal certainty asks us to respect what, in the form of authoritative issuance, the organs for lawmaking issue law in the proper forms explained in the Constitution, that we respect this no matter what its content is. This is legal certainty. And now this conflict, for Radbruch, we have to give precedence to legal certainty, because often people can argue about justice. We have different ideas about justice. But for some aspects, and the Holocaust, I think Radbruch had this in mind because he was writing this when the Holocaust had actually just happened. There are things on which there is, from a moral point of view, no reasonable disagreement possible. And positivists would say there is no such point we can reach. Disagreement on moral questions is always reasonable. Now, this sounds plausible if you say it in the abstract. If you look at something like the Holocaust, it strikes me as fanatic relativism to say that I don't like the Holocaust, that millions of people, for purely racial and religious reasons, were killed. Women, children, and so on, is, so to speak, a statement of taste. Whether you like it or you don't like it, but there can't be a reasonable argument about this. And which is, of course, a key question in political philosophy. But the working assumption, we are not political philosophers, we are lawyers. The working assumption, and this is very striking, I think, for everyone who has worked in public international law on the idea of human rights. Well, of course, we argue about the content of human rights, whether there are these second generation rights and first generation rights, economic redistribution, solidarity, liberty, equality, legal equality, factual equality, equal opportunities. All this is a political debate. But the idea of the Radbruch formula, Radbruch and Alexi, is there comes a point at which you cannot reasonably differ, that you cannot do something like the Holocaust. And this is basically what the Radbruch formula tries to put into a single formula, that positive law, authoritatively issued and socially effective, applied by the courts, obedience by the population. But still, it is so unjust that we cannot regard it as law. I taught this for about 10 years, saying this is fortunately something, if we look into the past, but that is not something that is an actual issue. I'm not so sure anymore that in the world there is not extreme discrimination, basically in some form of racism that is actually informs state practice. But let's hope that we will not, in the presence or in the future, reach a state where we have to say these are instances of the Radbruch formula. This is, so to speak, the fundamental idea. Yeah? And legal positivists, Kelsen would say no. It's you can never have actually a justification of a moral statement. This is all subjective. Full stop.
Thank you. It's a very interesting presentation on the Radbruch formula and also on Alexi. I would like to hear more of your own thought on the ex nunc ex tunc discussion. Because I think it goes back to the legal certainty question. Okay, we have to say that this is, from now on, it's not valid. But it's granting some sort of status valid for the previous time. So I'm wondering if you have considered that. I know it's probably the answer is we have to, for legal certainty reasons, we have to abide by this previously for the past, so not giving the next tunc effect and just moving forward. But I want to hear probably on your own thoughts. What do you think of can we say that it was invalid all the way, or we are just invalidating from now on?
Yeah, I think, so to speak, my first impetus is to ask the question in the first place. Because as far as I can understand, so Radbruch was a criminal lawyer, and when he was writing in 1946, constitutional review in the structures of the former German constitution, the Weimar Constitution, there was no developed system of constitutional review as we know it today in there. So it wasn't really known. So but with Radbruch, the case is a bit difficult. What did he assume? But he acts as if assuming that something falls foul of the Radbruch formula, it is ex tunc from the beginning on invalid. And with Alexi, it's a bit difficult because all these post-war, the post-war constitution was already in place, and Alexi taught constitutional review for decades in Kiel. I actually attended his lectures. So the structure was small, but Robert Alexi didn't explicitly, insofar as I can see, address this question explicitly. He simply did what one normally does. You assume that you know from your own legal system is correct. It's the only way to deal with it. It's the kind of predicament of the known solution that you have. And so in his writings, this is also present. At the end of the day, if in positive law something is issued, whether it's a general norm or an individual act, we have the dynamic structure in positive law, I think that Kelsen very well explained, which is not to kind of endorse his positivism, but with the dynamic structure of positive law, he was very good in explaining that. And of course, that this plays a role for legal certainty to honor and respect some things that were laid down in space and time at a certain point in time. The idea of the Radbruch formula is that, by and large, this is also a difficult debate, but by and large, I think the key idea is that natural law is basically universal and eternal, and that it doesn't have this dynamic nature that Radbruch explained. So, in that sense, I think honoring changes, so to speak, in positive law as a matter of legal certainty. If you've come to the conclusion that something is extremely unjust, it doesn't strike me as, so to speak, a very convincing idea of say, yeah, but it was extremely unjust, but now we laid it down 10 years ago, so now we have to go with it. Because of the static nature, I think that goes against the distinction you made. And this is why I'm kind of inclined, I'm thinking out loud here. Yeah, this is to be perfectly honest with you, thinking out loud, but my inclination is to say, if I've come to the conclusion that it's extremely unjust, and I can say this with sufficient certainty as the case of the Radbruch formula, then to say, yeah, but I have to respect that it was by structures and positive law and have to honor this in a certain sense, but this ex-nunc strikes me as unconvincing. But I have to think a bit more on this. And thank you for inviting attention to this very important aspect. Thank you.
Good morning. My name is Ricardo Marin. I am a PhD student here now.
Congratulations.
Yeah. Congratulations for your excellent Martin. I have a question about Gustav Radbruch.
Yeah.
I think that he maybe can share some elements with other great philosophers like Marx, like Plato, like Goethe, because I think that we can talk about a young Plato and an older Plato, a young Marx and an old Marx, and young Kelsen and an older Kelsen. I refer that there was a change in his thinking in their philosophy. Do you think that Gustav Radbruch can fit in this category? We can talk about a young Radbruch and an older Radbruch, and if there's a change.
Yeah, you compare Radbruch with very famous figures, of course, and Radbruch was very modest, and I think he would have disagreed vigorously, so I do this here on behalf of him. Aside from this formal protest, yes, there are I would say his theory developed over time. And H.L.A. Hart, and because the article by H.L.A. Hart was very influential for its own reasons and for Hart to speak. I criticize Hart here, but of course he did wonderful things at that time. Famous, Hart alludes to a conversion. And now things in Radbruch's theory changed over time. And there is a debate, you could call this a kind of renaissance of Radbruch, kind of newly developed questions on Radbruch over the last, I would say, 15 to 20 years. With the 2000s, it kind of begins a kind of new phase on the interpretation. And this conversion theory that Radbruch was a positivist before, people say the war, this isn't really precisely what's changed. It's his legal philosophy in 1932, his main work, his book, Legal Philosophy in 1932. There's an English translation, which is bad, I have to warn you. Some people say he's a positivist there. And if you look in isolation at one passage, it looks like a positivistic book. But if you read the rest, it is certainly not a positivistic book. This is part of the problem. And that his theory of validity in 1932, that changed with the Radbruch formula and the 1946 theory of validity, which is then the interoperability formula. So there was a change. Certainly there was a change. It wasn't a change, I would argue, from positivism to non-positivism. it was a change, I would argue, inside the non-positivistic spectrum. Because if you assume a necessary connection between law and morality, this is, so to speak, non-monolithic position, because you can have different kinds of necessary connections at different levels, and the necessary connection can be stronger or weaker. So this is, so to speak, a whole world. And Radbruch's position inside this spectrum of non-positivism changed. And it is, I would say, frankly, false that he was a positivist and he became a non-positivist, which is complicated, admittedly, by the fact that Radbruch says, after the war, I was a positivist before the war, which is wrong. Okay, but I think this can be demonstrated. Of course, this is why people who are like hard going in this conversion theory direction are, yeah, how to put this? They kind of are lured into a kind of trap by Radbruch himself. And now if you, this is the same with the disavowal formula. Radbruch also has a perfectly misleading word in his disavowal formula, which if you look at the greater thing, turns out to be perfectly wrong in his own view. But you need some interpretive effort to come to that conclusion. And if you want to compare Radbruch with great philosophers, maybe he is one, I don't know, this is for others to decide. If you compare with great philosophers, I think it is always helpful if you want to be discussed. It is helpful to leave some room of interpretation for others and some screen on which others can project interpretations from their own point of view they want to have of your own theory. So in some sense, if you present your own theory with the greatest clarity possible as an academic, you may actually harm yourself, because people agree or disagree but move on to something else, but not start having, so to speak, big interpretational issues about the theory of X, Y, or Z. Now with Kelsen, the situation is, Kelsen is always very clear if you have a piece of Kelsen before you. He's very clear if you read him. The problem is, he goes into different directions very clearly if you have different parts of his writings. So the complexity with Kelsen comes from other sources. With Radbruch, it's also his language, which is always often some kind of opaque. And coming from an analytical tradition with Robert Alexi, he does analytical stuff. Radbruch's language is, we are not impressed by his language, but you have to admit, in terms of clarity, you have to admit that Radbruch had a very good intuitive grasp of issues. I think he was very a great talent, not the greatest talent in carving out this with the greatest precision, but he felt where the problems were and kind of, in a not very clear language, explained to us where they were. And this is, I think it's a good starting point. This is why I love talking about Radbruch, because it makes sense if you can make something out of him, but you need some interpretive effort. And it's very easy to look at Radbruch and not see this, what I'm seeing in him. So maybe there's also much reasonable disagreement possible on that.
Congratulations, Dr. Borowski. When I listen about Radbruch, I remember my first steps in college, because I have a first university that was the University of Panamericana, and then the one of the lessons that Panamericana touched me more was Radbruch. And like Ricardo said, we had two Radbruchs, one after the war, the other.
I'm not so sure.
Nowadays,
Yes.
the world is so full, so crazy, that the autocrats are in power. What lessons we can take about Radbruch to have a little light? Because I remember so well, Radbruch has a lot of lights in the power, but a power with conscience, I think.
Yeah, it is always very difficult to apply, so to speak, very abstract insights from legal philosophy to very concrete political contexts, and I would be hesitant to do something like that. I think what legal philosophy at university level can do is to kind of inform, to kind of transport through the generations that there are key questions. And this is what I say to my students when they attend the first year lecture on legal philosophy. I tell them, we don't have actually a kind of a precedence here. You don't have a Bundesgerichtshof judgment you have to learn by heart, and you're not allowed to depart from them. We have authority, but this is rather academic authority, kind of authority of wisdom, but not formal authority. And what I want you, because you, speaking to my German students, not you here, you will be at some point be in a position of power. You will be part of the legal system in this kind of structure of competences. You will be bound by some things, and you can't really change much about this, but you will have some discretion to kind of work out the legal system in your corner to a certain extent. And I cannot tell you that Radbruch is right or Kelsen is wrong or the other way around, but what all we can do is kind of inform you that there were debates of people having experienced these problems in reality. And about that, they thought hard about this, thought how can we approach these things, and there are positions and there are arguments. And when you are there, you will not, so to speak, have to start from scratch, but you might have thought and reflected to a certain extent. I tell them I'm a non-positivist. You don't have to be. There are arguments. And it's a perfectly respectable position if you look at the arguments to be a positivist, because they say I prefer these. It's typical for many people, unlike Radbruch, to move between positivism and non-positivism back and forth throughout a career. That's perfectly fine. The only thing I can speak help with is that if you're in a situation that you have reason to think about these questions, you do not have to start from scratch. You do not feel you have to be alone. There's no one else who has ever thought about these things. There are these things. Look at them, decide for yourself what is for you convincing and what is not. And I think this is what, so to speak, this is a realistic light that academic teaching and legal philosophy can provide, not much more. If people decide there's a kind of autocratic system and they say, well, this is positivism, some kind of exclusive positivism, social facts thesis, it's only just social facts, law is no ideal dimension, it's kind of a structure of power. I don't have a pistol to put to their heads and say, no, Radbruch's right, this formula and this, I can't do that. So this then, unfortunately, has to be, so to speak, sequentially. You have to then thought after the rogue system. You have actually realized it was a rogue system, and it was overcome, and you have the freedom to think and speak about that. Then you can address these questions in the situation. There's a debate as to whether non-positivism can prevent rogue states. These arguments are in there, but they are admittedly even admitted by non-positivists. They are not horribly strong. They can, I think, they can help something, but it's a modest effect. To be honest, this would be a kind of tentative reaction to the need for a light at the end of the tunnel, which is hopefully not the oncoming train. Yeah.
Well, thank you very much.
Thank you
for being here and for your interesting presentation. And we will see you next week.
Thank you. Yes.
Yes, just to continue talking about these topics.
No philosophy, methodology. Yeah. Yeah, thank you for your kind appearance and for listening attentively. I could see this and asking good and deep questions. Thank you. This is